court is now in session. Please be seated.
All right. Madam Clerk, you may call the next case.
State of Tennessee versus Joseph Ray Daniels.
Good morning, Your Honors. Todd Ridley on behalf of Mr. Daniels. If I could reserve 3 minutes for rebuttal.
Yes.
Thanks. Okay. Today, I'd like to talk about 3 distinct but related issues. I'm not going to talk about the 4th issue in the brief. I'm just going to talk about the Bishop issue, the issue regarding the confession, and the last issue is the excited utterance issue. And these are all distinct, but they are somewhat interrelated, given in that the proof on each sort of blends into each one. But I'll begin with the Bishop issue, and Bishop concerns the corroboration of Mr. Daniels' pretrial statement to police. So in Bishop, Tennessee adopted a modified trustworthiness standard, and this is a modification to some degree of the corpus delicti rule that had existed for hundreds of years. The modified trustworthiness standard that Bishop announced requires proof of 2 things in a case like this where there's a tangible injury. The first is, did the state provide independent prima facie evidence of Joe Clyde's death? That is the victim in this case. And the important part is that the state needs to provide independent evidence of the death itself, not the underlying felony, which in this case was aggravated child abuse. So it can't just be evidence of hitting or of anything else. The state needs independent proof that the child has died. They did not do that in this case. The second thing that is required is the state has...
What would that be? The way I understand this, you're asserting it cannot be proven without a body.
We're not saying it cannot be proven without a body. Because there is not a body in this case, it's much more difficult to prove that there was a death.
Can we ever meet that burden without a body?
I believe you certainly can. I mean, the other cases since Bishop that this court and the Tennessee Supreme Court have looked at, in both there was no issue proving that. The state had no issue proving that. Okay. In this case, there is a challenge. And that challenge really stems from the existence of the corpus delicti doctrine in general. So pre-Bishop, or really even going back much further, this case might not even been able to be brought. Bishop gives the state an opportunity to bring charges in cases like this, but it puts on them a requirement to prove these 2 things. And the first one being independent prima facie evidence of the death. In this case, they don't have that. The second thing they have to provide is substantial independent evidence to corroborate the details of Mr. Daniels' statement. Again, the state failed to do that in this case. Now, the remedy for this error in this particular instance is vacating the conviction and dismissing that portion of the case. So Mr. Daniels has several different convictions, but the first-degree murder case would go because of the lack of corroboration and the lack of independent proof of the death. I guess I'll get a little bit into the particulars of Bishop in that other than establishing the independent proof of the death itself, the state also has to have substantial independent evidence to corroborate the details of the confession.
I'm sure you're going to get there, and I don't mean to interrupt you, but the state alleges it did. Clearly it did, through the testimony of the older brother, Alex.
Okay.
I mean, is that not independent proof?
It could have been independent proof had the details of Alex's testimony matched in any way, the physical proof or the confession. There is no physical proof to confirm anything that Alex testified to. There is no independent proof that where Alex's testimony, I'm sorry. Yeah, so Alex's testimony, to the extent that it was brand new, So he had had, I think, 55 interviews with DCS prior to trial. In none of those did he say anything about this. It was only at trial and really in the month leading up to trial that this story developed.
So is your argument about the state's, what they purport to be their corroborating evidence, more of a credibility determination about a witness?
I don't think it's just a credibility point. Normally, if that were the only issue, if it were credibility, that would be something for the jury to decide. But under Bishop, we are looking at a legal question that the court needs to decide before this case gets sent to a jury. So that's the biggest problem. The second is that Alex's testimony, because it is so inconsistent and because it is belied by so much of the physical proof, it cannot serve as corroboration simply because even if you believed everything he said, it doesn't corroborate the details of the confession because it's so radically different from what Mr. Daniels said.
Well, I'm going to let my colleague speak to this issue because he's going to talk about.
Okay, here's the other, it's not just Alex. Because, you know, you have this confession where he says he took the body and threw it off a bridge.
I mean, he said several different things, but yes, that's one of the things he said.
And then you have, and I forget her name, there was a woman who was driving to work, middle of the night, sees a man standing on the bridge, dressed in the same kind of clothes that the defendant had. And that is also a corroborating factor that was brought out at trial.
I'm not sure what detail that the female, I think she was a bail bondsman, I'm not sure what detail of the confession that corroborated. And
Well,
it certainly didn't corroborate any detail relevant to this offense.
Well, let's get clear, because he gave several.
He gave
Several,
multiple.
and he also took the police to several locations where he purportedly disposed of the child's body.
Correct.
One of which included the bridge, which
Correct.
was corroborated by this witness.
I think the only thing that corroborates, if at all, is that Mr. Daniels was in a particular area at a particular time. It does not corroborate more than that.
But,
So,
but you know, you downplay that, but if you take it as a whole, if you take the proof as a whole, yeah, he said a whole bunch of things. But one of the things he talked about was, I threw this child off the body off a bridge.
okay.
And this woman sees this man standing in the middle of this, like 3, 4 in the morning. She's going to work, wherever it was, and she sees him on the bridge wearing the same kind of clothes that he had on the night that this happened.
I think then we would get back to the first problem of the state hasn't proven that there was a body and that there was a death in the first place. So let's say that she saw that and that corroborates a portion of the confession. Wouldn't you expect the body to be found there? That is fundamentally the issue with the corroboration problem, is that none of it matches what Mr. Daniels said. So he made a number of statements that contradicted themselves, contradicted each other, and what the state was required to do was to put on proof that corroborated at least some essential detail that would establish that an offense happened.
What you're hearing from this panel is that there was some.
There was some.
And then then you can see there was some. It doesn't take a lot. Our case law doesn't require, a lot. As a matter of fact, as emphasized by the state in their brief, it really is less than a preponderance of evidence that's required for corroboration, right?
That is correct.
So what are we talking about?
Well, I think what we're talking about is that it has to corroborate a particular part of the confession. So what we're only getting is we're corroborating incidental collateral details that don't go to the fundamental aspect of the offense. So one of the things that I think is the Willis case talked about is that, yeah, corroboration does not require very much, but it does require that it corroborate not some incidental circumstantial fact. It doesn't, if it just corroborated that Mr. Daniels lived at his house, well, okay, that corroborates a part of his confession, but it doesn't corroborate anything about the offense. And so what we have here is Mr. Daniels saying, among other things, yes, I was near a bridge, and we have a witness who saw him at a bridge, but the part of that matters for this case is did Mr. Daniels dispose of the body off the bridge? And if the state had found the body there, then that would certainly corroborate it. And the state wouldn't have any problem proving the first prong of Bishop because it would be able to prove that there had been a death. But here what we have is a state's witness who certainly can confirm a small incidental detail of the confession.
And the smaller brother, I mean, the relations are not, I don't have them solidified in my head. You've got the older brother, Alex, and the younger baby, I guess Noah, who said, Joe dead, Joe dead, Joe dead.
And that,
then
again,
the
is why,
confirmation of the aunt saying, yes, baby, Joe dead.
and again, that's why these are all interrelated
Yes.
issues.
Yes.
So I guess I'll just go from there to...
I'm sorry, I'll let you go ahead.
No, I will go from there to the hearsay issue, just get to it, because that is what the state relied on, or those two things are what the state relied on to establish that there was a death that occurred and to corroborate the confession. So at trial, the state maintained that Alex, the older brother, and Noah were what the corroboration was. It didn't rely on the witness seeing him on the road. It relied on those two critical
But that
things.
was still proof that the jury considered.
That was proof that the jury heard, but the Bishop analysis is a legal question that the trial court needs to decide. So the jury can decide certain facts, and certain facts are going to go to the jury, but Bishop is a legal conclusion that needs to be done before any of this even goes to the jury.
And the trial court did that. There were multiple hearings here in this case, correct, regarding that issue.
On the timeliness, yeah, we had some quibbles about how that was done, but not on this appeal. But yeah, back to the hearsay part, because that was an essential way that they corroborated it. So the state claimed we proved that that a death had occurred because of Noah's statement, Joe dead, whether it's a question, whether it's a statement, and then Aunt Joyce's response. So the problem there is that the state did not call Noah to testify. The state did not call Joyce to testify at trial. They got that in through law enforcement officers who overheard this interaction. So to get that in, the state was forced to get around the hearsay rule. They claimed that it was an excited utterance, and the trial court admitted the statements of Noah and Aunt Joyce as excited utterances. Neither qualified. So an excited utterance, again, that's a de novo question for this court to decide on the first instance. Decide under de novo review. And what we have is an issue where the state has kind of changed course a little bit. When at trial, I understood the kind of incident that elicited the excited utterance to be the missing child. The state has now kind of sort of pivoted to the excitement, or the exciting incident is just the presence of law enforcement. Either way, the state can't meet its burden to get this admitted into evidence. So the first problem, I would say, is with Aunt Joyce. The officer who introduced this evidence did not see, or one officer could witness Aunt Joyce and Noah. The other officer could not. He just saw. And neither officer were able to testify about how they seemed, how they sounded when they made these statements, whether they were jittery and agitated, nothing of the sort. And the trial court looked past that and said, well, this was a stressful situation and any child would be in an excited state because of the stress of the situation. And I think where the trial court was framing that is the stressful situation was the presence of many, many law enforcement officers.
But isn't that related to the missing child? All of this kind of, in my mind, and I don't know if there's a timeline. I don't know how long after the initial report of the missing child occurred until law enforcement actually showed up. So I'm not real clear on all of that.
So the timeline is, for this part of it, is actually pretty clear.
Okay.
So the initial 911 call, I think, is about 6:20 in the morning. Law enforcement arrives maybe 20 minutes later.
Okay.
And then throughout the morning, many people are arriving on the scene and people are talking to Aunt Joyce and really the whole family in the living room. At this particular point, Joe, or my client, has gone with other officers to participate in the search. And I think around noon that first morning, or that first day, the law enforcement is conducting a missing persons questionnaire with the family, and that's when this statement was supposedly made. So the problem with kind of thinking of it all as, well, this was all excited or all kind of stressful and exciting, so anything that would be said was in that, would have been under the excitement of that condition, is that it would transform pretty much any police investigation into a climate where an excited utterance is possible. So anytime the police show up to investigate a crime, no one would deny that is a stressful and exciting, I guess.
But this is a missing child. I think they were under the assumption the child had just walked out somewhere and they were looking for him. So this was fairly early on in the events.
And not only that, this is a statement specifically about said child. You understand what I'm saying? So this is not just comments about a general investigatory procedure. I get your argument, but this statement is a little, to me, more specific in terms of this child is saying Joe dead, the victim dead, the victim dead. So I'm not as bothered that this might have a broader effect on the excited utterance rule.
Okay, then I guess then turning to the specifics. Generally though, when we have an excited utterance, the state's gonna put on proof about the condition of the speaker, or the declarant in this case.
Fair.
And so normally, kind of the paradigmatic excited utterance is somebody's robbed, they run into their neighbor's house and say, I was just robbed, it was this guy. And then, great, because then we have the neighbor who can say, she was, or he was in a state of distress, she was frantic, etc. In this case, none of that happened. What we have, in fact, is quite the opposite. We have one person who just overhears it, and the person who saw it didn't take note of it, didn't do anything about it, didn't follow up further or ask more questions about it, just said, well, he came in and said that, this is how the aunt responded, but nothing to say, well, the aunt was crying and she was in a state of distress when she said all of this. Everyone just kind of assumed, well, this seems like it would have been a stressful situation and many people would be stressed in it. Therefore, Aunt Joyce and Noah must have been as well. Maybe, maybe not, but that's not what's important. What's important is the state elicit proof on that, and they failed to do so. And I see I'm very much out of time, so I'm gonna save the rest of my time to the extent I can
Thank
for
you, Mr.
rebuttal.
General?
Good morning, Your Honors.
Good
May it
morning.
please the court. Garrett Ward here today on behalf of the state of Tennessee. Your Honors, this court must affirm Mr. Daniels' convictions for principally first-degree felony murder and the perpetration of aggravated child abuse because the state has sufficiently proven this conviction, including satisfying the Bishop corroboration requirement, and because the evidentiary issues raised by the defendant don't rise to the level of reversible error. I will devote sort of the bulk of my time, I imagine, to what is really the central issue in this case, and that is corroboration. This case, it's a bit of an interesting union between the Bishop requirement that an extrajudicial confession be corroborated, which is not necessarily the most commonly litigated issue, with a pretty unusual factual circumstance, and that's a homicide prosecution where a body is never recovered. I'll acknowledge for the court that is sort of an odd set of companions. But I do think the state here put on the necessary proof, and I'll discuss that proof with the court. But before I do so, what I think this court should focus on is what is, and Judge McMullen, you touched on this during Mr. Ridley's argument, you touched on what is the standard here that corroborative evidence needs to meet. And the way this court and the Tennessee Supreme Court have described it is less than a preponderance of the evidence, but more than a scintilla. Your Honors, this court could hardly have used sort of words that more lower the magnitude of this requirement than somewhere more than a scintilla, but less than a preponderance of the evidence. And that's what led this court in the Champion case to acknowledge that, look, this is a modest requirement. And this makes sense because we're not trying to independently prove a case with this evidence. We're trying to corroborate a confession, which does largely touch all of these elements. So it makes sense that there's this incredibly low evidentiary burden. So I think that really needs to be foremost in the court's mind as we consider what the proof is in this case, because it is so atypical for corroboration cases.
Can the state get to corroboration without the excited utterance?
Yes, Your Honor.
Okay.
So speaking directly to that, really the centerpiece of the state's corroborative case here, both for the requirement that the state prove a death occurred, because this is a case with a tangible injury, in this case a death, so we need state sort of independent proof that the death occurred, and substantial evidence that corroborates some essential facts of the confession. The centerpiece of the state's case on both of these is the testimony of Alex, which sort of stands alone from the excited utterance. And I'll certainly talk to this court about what Alex said, but since we're talking about corroborating the defendant's confession, I think it's wise to at least briefly touch on what exactly the defendant confesses to, since that's what the state is ultimately going to have to corroborate, is what the defendant says. And as for sort of the core of the confession, sort of what happened to Joe Clyde, the defendant largely says the same thing on a number of occasions, with some admittedly inconsistencies on the ultimate, where he ultimately disposes of the body. But the core of the defendant's confession to the crime is that at some point in the middle of the night, Joe Clyde Daniels, or Little Joe, had an accident. He wet the bed. That in the course of sort of dealing with this incident, the defendant got a little angry and began to hit Joe Clyde with an open and then a closed fist in the living room of the home he lived at, 15 to 20 times, I believe, what he testifies to in his initial confession. And then he throws Joe Clyde against a coffee table in the living room. Joe Clyde loses consciousness in the living room. The defendant then, after some period of time, picks Joe Clyde's, at this point, body up from the living room floor and carries it outside, sets it in the lawn, or sets it down on the lawn. So that's really the meat of the defendant's confession. What Alex testifies to at trial is far from radically different from that. It's actually pretty consistent on those key facts. Alex gives similar testimony about the urination incident. And then Alex says that he fell back asleep and that he is awakened by a loud bang coming from the living room. Then he uses a rather curious phrase. Alex says that he waits a few moments for things to cool down. I note that specific phrasing for the court because what that clearly suggests is that this isn't the sort of bang one might hear when a picture frame falls off the wall or somebody drops a plate. There's some sort of ongoing commotion, and Alex is waiting for that to stop. This isn't one loud sound. This is a loud bang that wakes him up, and then stuff keeps happening. So Alex waits for things to calm down or cool down. He goes outside into the living room where the defendant in his confession says he beat Joe Clyde. He sees the defendant standing over Joe Clyde, sees the defendant pick up Joe Clyde's body, carry it outside onto the lawn, and set it down. Then Alex waits a few moments, and then he goes outside. I guess he's a small child at this point. He wants to know what's going on. Sees Joe Clyde still on the ground. He ultimately is, according to Alex, and then actually according to the defendant's confession as well, the defendant sees Alex, and then both of them say that the defendant made some sort of threat towards Alex. One of them says that he threatened to kill him, and the other threat says he threatened to beat him, but that's a fairly insignificant difference, I'd suggest to the court. And that's the centerpiece of the state's case here, and I want to briefly note one thing for Alex, because I think it's interesting that Alex is the centerpiece, because he's the person that, from the defendant's own statement to police, we would expect to be the centerpiece. This is the person that should be the centerpiece, because what the defendant says time and time again is Alex saw everything, Alex can tell you what happened, and essentially Alex is the person you should be asking. Well, that's exactly what we have here, Your Honors. We have Alex, the person who the defendant says should be able, essentially says, if anybody can corroborate my confession, it would be Alex. He doesn't use those words, but that's the upshot of what he says. And then we have Alex doing that at trial. And these aren't sort of ancillary details that Alex confirms. He confirms the location, certainly, and of the living room. Certainly, he doesn't see the beating.
What about the condition of the victim's body? I think that's really what the gravamen of the defendant's argument is, that we don't have, I don't know what the exact language is, independent, tangible proof of the injury.
Certainly,
here.
Your Honor. And then sort of specifically to that, I do think just in looking at Alex's testimony, keeping in mind the sort of what the evidentiary standard is here, Alex says he sees the defendant pick up Joe Clyde's body from inside the house and then carry it around for some amount of time, some minutes, set it on the ground and then pick it back up. All of this time, this body is just being carried around. No, Alex doesn't go to this body and check it for vitals. But what he describes is exactly what we would expect the body of a recently deceased child to be. No, he doesn't check for vitals. He can't say with the certainty of a medical examiner that when he's watching his baby brother being carried around by his father outside during the middle of the night, after seeing his father pick him up from the floor after hearing this loud bang, no, he doesn't get his pulse. But what he testifies to is exactly what we would expect him to testify to if he's watching his recently deceased brother being carried around. So I'd suggest just on that is sufficient corroborative proof, just on Alex's testimony, both on the death itself and essential facts. And there's some more corroborative proof that I'll briefly discuss with the court. Judge Campbell, you mentioned the testimony of the woman who saw the defendant at the bridge. That's Ms. Jones. That does corroborate at least one of the later stories about disposing of the body, and then corroborates more broadly something that's consistent with all of his stories, is that he leaves his property sort of early in the morning. That's corroborated from her testimony. I'll discuss the excited utterance as sort of a legal issue in a moment, but that proof, which was admitted, does corroborate the state's case here. So for purposes of evaluating, Bishop, it's proof that this court can and should consider, although I again contend it's not necessary given the strength of Alex's testimony, particularly considering he's exactly who we should be asking.
So the other piece before you move on to the excited
Certainly,
utterance is the defense appears to attack inconsistencies within Alex's testimony. What's your position on that?
Really two things, Your Honor. First, Judge Mullen, I think that's really just a credibility attack without exactly saying it. And those were certainly arguments that the defendant can and to some extent did raise with the jury, and did raise with the trial court. And I think the reason that those sort of fall flat in this case really leads me into my second point, is that we are looking here for evidence. I forget the name of the Supreme Court case. It might be in Bishop itself that says, look, we look to this evidence and see whether it meets this burden, and then we consider all sort of contradicting or problematic parts of this evidence itself. I understand opposing counsel's argument, and I'd likely be making the same one, but fundamentally what that does is it inserts sort of an additional requirement to this very low preliminary burden that the state has to clear, and essentially says not only do you have to put on this evidence, you also have to answer, despite the fact that the Supreme Court said you don't have to, you also have to answer for any problematic parts of it, any inconsistencies, any contradictory evidence. But that's not what the Bishop requirement mandates. It mandates this low burden, more than a scintilla, less than a preponderance. Your Honor, this court could look at the evidence and say, we're not convinced that more likely than not this happened based on Alex's testimony. And that may be, but that's not what the state's not required to prove that. More than a scintilla, but less than a preponderance. So to the degree this court looks at Alex's testimony and the rest of the case and says we still have some questions, it's completely fine considering the evidentiary standard here.
All right, is the excited utterance supported by the evidence?
Yes, Your Honors, and I'd like to deal with each statement a little separately because there are some pretty significant factual differences when it comes to these two statements. And to clarify with the court, the two statements are sort of Noah's statement where he says 3 times in rapid succession, Joe, Dad, and then a response from Aunt Joyce. And I'll address Joe first, or pardon me, I'll address Noah first. Your Honors, there is some testimony about Noah's state and just about about who Noah is that I think this court must consider when it comes to evaluating an excited utterance. Noah is, I believe, 3 at the time this occurs, and there is testimony at, I believe, both the suppression and at the trial that he makes this statement loudly. The officer does offer at least some amount of insight into how Noah is sounding when he says this. We do have some of that here. So when we're looking at excited utterances, really what we're looking for is there sort of a startling event? Is there a statement made that relates to that startling event? And then is there evidence suggesting that the declarant is sort of laboring under that excitement? Frankly, Your Honors, I think at least a couple of these elements are rather easily met here. This investigation, this sort of hive of activity around the defendant's home, sort of in the initial hours after this 911 call, I can scarcely create a more sort of exciting event. Far from sort of a normal police investigation, there's an insightful piece of testimony from trial. I want to say it's the police chief for Dixon County says that this is the largest search conducted in the history of Middle Tennessee. Mr. Ridley, my friend on the other side, acknowledged there are innumerable officers. There's innumerable officers in and around this home. There are K-9 units. I
think they concede the first 2 prongs.
So concede the first 2 prongs.
So speak to the third.
Speak to the third. Certainly, Your Honor. So as for is Noah laboring under the excitement of this event, Your Honors, I'll admit for the court that this is not sort of the paradigmatic excited utterance case. And largely that's because this isn't the paradigmatic declarant. This isn't the adult who's recently been robbed. This is a 3-year-old child who wanders into a room with a bunch of adults he doesn't know and says in an elevated voice in rapid succession with no prompting, nobody is addressing him. A 3-year-old walks into a room with a bunch of strangers and then loudly says, Joe, Dad, Joe, Dad, Joe, Dad. I'm not going to stand before this court and yell. But when a witness says a 3-year-old walks into a room full of strangers and says something loudly, I think this court can probably draw some conclusions about what that 3-year-old probably sounded like based on that testimony.
I probably would in retrospect. What is concerning is that no one in the room did.
So I can speak to that briefly, Your Honor, because it struck me as a little odd when I first read it too, and then as I read on, sort of the testimony of the person who testifies to this, they're not sort of at that point principally there investigating a death. The person who testifies is on another. He's on another mission at this point. He's talking to another adult. He's filling out a lost person questionnaire because at this point, that's the presumption that law enforcement is operating under. They're expecting to at some point find this child because they've been told he sort of got out in the middle of the night and is missing. So yes, this statement is said near him. He notes it. He doesn't stop what he's doing. He's doing something that's frankly very, very important in these early hours after a disappearance, is getting information from the sort of adults in the room who might know things. That's what he's doing, and he overhears this statement. And sort of in the ideal case, certainly, Your Honors, I'd rather be standing before this court saying he immediately stops doing what he's doing and goes over and talks to Noah. But he's doing something important. That's the task he's on. He notes this comment. He is able to recollect both at the suppression hearing and at trial at least some of what the comment sounds like, how Noah says it. And I'd suggest to this court that sort of looking at all of this in totality, that it does meet, that it
And no one even followed up on the aunt's response. Yes, baby, yes, Joe did. I am, if you're looking for a missing child and you have this big whirlwind of authorities, and I know you're close to your time, but that doesn't trouble you that the state didn't try to tease this out more, or at least pull out from why no investigator said anything to the aunt, or there was no proof that there was anything said, or there was no follow-up? There was nothing.
And to some extent, Your Honors, it's sort of the ultimate question of why does this officer continue doing his questionnaire. I can't offer much more to the court than he's conducting this questionnaire. He's interviewing a specific person. He's in the middle of doing this, and he overhears this comment. It's clear he overhears it. There's no doubt about that. No, he doesn't stop doing what he's doing, which I think we'd all agree is an important and valuable thing for him to be doing. But it's the state at trial couldn't really tease more information out of the situation. The facts are what they are. At least for Noah, I think the facts are fairly compelling. I'll acknowledge it is a closer call when it comes to Aunt Joyce. We don't have, is a qualitative difference between the two. We don't have the same level of testimony about how does she sound. All I can really say is that she says it immediately without hesitation. We don't have this testimony like we have for Noah, that she is, speaking loudly. But we do have that for Noah. I'll acknowledge we don't have that for Aunt Joyce. But regardless, Your Honors, I do think even if this court disagrees with me that one of the statements, or perhaps both of the statements, are excited utterance, I'd suggest to the court these admission of these statements, even if erroneous, was harmless. And I've really got two brief points to make on that. First is putting the bishop requirement to the side for the moment, in terms of, is this what the jury's determination hinged on? Absolutely not. The jury's determination here hinged on the much more compelling and specific testimony from Alex and the defendant's full and explicit confession to this crime. As for the bishop requirement, even without these statements, the state still clears that. Really the key witness here is not the officer who recalls a brief statement made by Noah. The key witness here is Alex, who gives explicit testimony about hearing the attack, about seeing the aftermath of the attack, and then about seeing his father carrying around the body of his baby brother. Unless this court has further questions, I'd ask that you affirm.
Thank you, Mr. Ward.
Thank you.
Ward, I'm sorry. Well argued and well briefed. Oh, I'm sorry, you have your rebuttal time. Come on, Mr. Ridley.
Just a few things really quickly. So the state began its argument by saying it did not need Noah and Aunt Joyce's statements to corroborate the confession. Both the trial court and the state below disagreed with that. State and trial court below thought corroboration came from Noah and Aunt Joyce's interaction along with Alex's testimony. So now that we're on appeal and they don't think they need it anymore, they're willing to jettison it. But below, the trial court felt that it needed Noah's statement to corroborate to satisfy Bishop. And in particular, why it needed this to satisfy Bishop is because of the requirement that the state establish through independent proof the central fact of the death of the child. It has to be more than just the corroborating that a beating occurred. Now the reason for that is in Bishop itself. Bishop says if it's a felony murder case, it is not enough to corroborate the underlying felony, in this case abuse. You have to corroborate, or not corroborate, you have to put on independent proof of the death as well. Alex can't do that. Alex can't come anywhere near doing that. Not only because he's a child and didn't know, he didn't see anything that would lead him to say that he believed the child was dead. He certainly couldn't put on proof that would establish it conclusively the way the state is required to do. So With that, they need Noah's statement, Joe dead, and now it's kind of like it's a loud declaratory statement, but at trial it was presented more as a question, though it was indicated that it was said loudly. But nevertheless, the state needs that proof to establish the incident of death. If they don't have that, they can't get there. So in that sense, the kind of hearsay issue is kind of beyond just harmlessness. It caused harm just because of how much the state relied on it to establish its sufficient proof in general, but it really needed it to satisfy Bishop. And without it, they just can't get there. Lastly, on the excited utterance, just really quickly, the comments about the failure of the officers involved, or the officer involved, to stop and follow up with what was going on, that in and of itself would be a problem, and it would make more sense if he were the only officer there. But as the state itself has been talking about, there were innumerable officers there who could have stopped to ask about this. There was another officer outside the door who claimed to have overheard this interaction. He didn't do anything either. So it's not just the one officer who had something important to do. I understand that. There were multiple officers around to follow up on this. No one did. And no one else was around to testify about how anyone seemed. There were innumerable people in the room. Someone surely could have testified as to how these people seemed and behaved when they made these statements, but the state didn't do that. All they had was one person who was focused on this questionnaire and not willing to stop to engage with this, and another person who wasn't even in the room and just overheard it. If there were so many other people available to testify to this, then surely the state could have called one. Their failure to do so is why this was inadmissible and why the state simply cannot meet its obligations under Bishop. And for that reason, we'd ask the court to reverse the convictions.
Thank you, Mr. Ridley. And Mr. Ward, you're making our jobs very difficult by how well you've done today. Madam Clerk, call the next case.